Imagine walking past, just a typical bustling construction site in New York City.
Right, a totally everyday scene for anyone living there.
Exactly. You hear the jackhammers, you see the scaffolding, the workers in hard hats. I mean, it all looks completely ordinary.
Just another day in the city.
Yeah, but what if I told you that right out in the open, like hidden behind all that noise and the dust, there is an alleged multi-million-dollar fraud scheme operating like a perfectly well-oiled machine,
It really is wild when you dig into it.
right? I mean, a scheme involving prominent lawyers, specialized doctors, and perfectly staged construction accident.
Sounds totally made up.
It does. But welcome to your custom-tailored deep dive. Today, we are unpacking a scenario that sounds like, I don't know, a Hollywood thriller. But it's actually sitting right here on our desk in a stack of legal documents.
Yeah, and it really does read like fiction. I mean, we are looking at a system designed to explicitly exploit the very laws meant to protect injured workers.
Right?
And, weaponizing the medical system to generate just massive payouts.
And our mission today is to untangle a truly fascinating legal paradox. Because we are going to figure out how a company can lose millions of dollars to this highly orchestrated alleged fraud scheme.
Billions of real dollars.
Right, real money. And they take the alleged fraudsters to federal court, and then they get completely thrown out by a judge.
Which is just mind-blowing to most people.
Exactly. And it's not because the fraud didn't happen, or at least wasn't alleged to have happened. It's because they aren't considered the quote-unquote right kind of victim.
Yeah, it is basically a perfect case study in how the law separates the reality of financial loss from the strict, almost mathematical mechanics of who actually has the right to sue.
So to guide us through this, we have two incredibly revealing sources today. First, we have a brand new federal court decision, hot off the presses, dated April 16th, 2026.
Fresh data.
Right. It's from Judge William F. Kuntz in the Eastern District of New York. The case is called Ionian Re, LLC v. Gorayeb and Associates.
And that second source we have is just as important.
Oh, absolutely. Alongside that court document, we have a stack of specialized industry intelligence reports that pull back the curtain on exactly what kind of company the plaintiff, Ionian Re LLC, actually is.
And that second source, that is going to be the key to unlocking the entire paradox here.
Because of the disconnect, right?
Exactly. It reveals this massive disconnect between what the company called itself in court and how it actually operates out in the real world.
Okay, let's unpack this. Because to understand why this lawsuit failed so spectacularly, we first have to look at the jaw-dropping mechanics of the alleged scheme itself.
Right. We have to start with the fraud.
So starting back in 2018, the complaint alleges that a law firm, Gorayeb and Associates, specifically his named partner Christopher Gorayeb, started using these people known as runners.
And runners are basically middlemen.
Right, and these runners would go out and conduct Spanish-language OSHA training sessions for new construction workers.
Which is incredibly strategic. They are positioning themselves as helpful, authoritative guides to the industry, right?
Building trust.
Exactly. It's a brilliant way to build trust with a demographic that is often very vulnerable.
But they were allegedly targeting non-English speaking, often undocumented immigrants. And the runners would pull these workers aside and pitch them a very simple, very illegal idea.
The pitch is the craziest part.
It is. The pitch was basically stage a fake accident on the job site, report an injury, and you will get paid for not working.
Right. And if you're listening to this and wondering, how do you get a multi-million-dollar settlement out of a fake trip and fall?
Because a bruised knee doesn't pay millions.
Exactly. The answer entirely lies in the medical file. A sprained ankle might get you a few $1,000s.
Sure.
But to get the millions, you need to prove permanent, severe, life-altering damage. You need a surgery.
Which means you have to fabricate a surgical necessity. The workers can't just pretend they need surgery.
No, of course not.
They need actual doctors willing to put them under the knife for basically no medical reason.
And this is arguably the darkest part of this whole operation. The criminal documents list a very specific network of medical defendants. The claimants were essentially funneled to places like NY Ortho, which is run by Dr. Jeffrey Stone Kaplan and Dr. Matthew Grimm.
Wow.
Yeah. And they were sent to Dr. Joseph Weinstein for orthopedic surgeries and to Kolb Radiology and Lenox Hill Radiology for the imaging.
But how do you even create a paper trail for that? If I walk into a hospital right now and say my back hurts, A surgeon isn't going to just start slicing into my spine.
Well, you rely on the gray area of soft tissue injuries and subjective pain.
Subjective pain.
Yeah. According to the complaint, these specific medical providers allegedly ignored all the standard protocols. Normally, you try conservative treatment first.
Like physical therapy.
Right, physical therapy, rest, maybe some cortisone shots. But here, the doctors allegedly skipped the conservative steps entirely.
Just went straight for the extreme options.
Exactly. They relied on overinterpreted MRI results from these complicit radiology clinics.
Unbelievable.
And they created facially legitimate but completely false medical records stating that extreme pain management and actual orthopedic surgeries were immediately necessary.
Because in a personal injury lawsuit, especially before a jury, a pristine surgical record is like the ultimate proof of severity.
It really is. A jury sees a scar, they see documentation of massive pain and suffering, and the settlement value just skyrockets.
And the doctors allegedly get paid for the procedures through these litigation funding loans, right?
Yes.
So the law firm promises to keep funneling patients to their clinics, and the official documentation artificially inflates the lawsuit payouts.
It is a totally symbiotic ecosystem. Everyone in the loop allegedly profits by passing these manufactured costs onto the construction sites and their insurance companies.
So, okay, if Gorayeb is allegedly orchestrating this perfect crime, they must know they are under a microscope.
Oh, definitely.
Which leads to this completely fascinating logistical detail in the court document. So, Gorayeb and Associates handles the massive personal injury lawsuits against the construction sites, but they don't handle the workers' compensation claims for the exact same fake injuries.
Which is so strange because you would naturally assume a personal injury firm would want to handle every aspect of the client's case to, maximize their fee.
Right. But instead, according to the complaint, Gorayeb walks the clients quite literally down the hall to a different law firm in the exact same building.
It's so brazen.
It really is. That second firm handles the workers' compensation side, while Gorayeb pursues the personal injury suits. They keep the parallel tracks entirely separate, but perfectly coordinated.
And this separation is key because it isolates their liability.
How so?
Well, the second firm, allegedly at Gorayeb's direction, is the one actually sending the claimants to the medical providers, arranging the litigation funding loans, and building that fraudulent medical file.
So their hands are technically clean.
Exactly. Gorayeb can then point to that file in the personal injury suit and claim, hey, we are just relying on the official workers' comp records.
Wow. It's like a money laundering operation, but for legal liability.
That's a great way to put it.
You clean the dirty facts through a separate firm, so by the time they reach your desk, they look totally legitimate.
Yep.
But wait, so if the law firm is orchestrating both the fake accidents and the inflated medical billing, isn't this the textbook definition of a racketeering operation?
It certainly sounds like it.
I mean, it's organized crime in suits and lab coats. Why wouldn't the victim win this case in an absolute landslide?
Well, the legal problem here isn't whether the scheme sounds like a crime. I mean, the court isn't dismissing the seriousness of the allegations at all.
Right.
The problem is exactly who is trying to hold them accountable.
Because someone is left holding the bag for all these millions of dollars in fraudulent settlements.
Exactly.
And that bag holder is exactly who walked into federal court. So let's introduce Ionian Re LLC. They're the ones who sued everyone we just mentioned under civil RICO.
Right, the Racketeer-Influenced and Corrupt Organizations Act?
Exactly. Ionian claims that because of this massive fraud scheme, their general liability expenses ballooned by almost 500%.
That is a staggering jump.
It's nuts. They were bleeding money because they had to reimburse the primary insurance companies who were actually paying out these massive lawsuit settlements.
What's fascinating here is how Judge Kuntz slices this legal puzzle in half.
Go break that down for us.
So in the federal system, there are different layers of standing, meaning your actual legal right to bring a case.
Right.
The judge ruled that Ionian actually does have what's called Article 3 standing, which is just the baseline constitutional requirement.
Meaning they really did lose money.
Exactly. You suffered a real financial harm, and a court could theoretically fix it.
Because they lost millions of real dollars. The injury isn't just theoretical.
But, and this is the big but, they lack RICO statutory standing. And we should probably clarify why everyone wants to sue under RICO in the first place, rather than just filing, a standard fraud claim.
Because RICO is the absolute nuclear option of civil litigation.
It really is. It's the holy grail for a plaintiff. If you win a civil RICO case, the statute awards you triple damages.
Treble meaning triple, right.
Right. That means you don't just get your stolen money back. You get 3 times your actual damages, plus your attorney's fees.
Wow.
It is designed to be completely financially ruinous for the defendant.
But because it's such a massive weapon, the courts put a very heavy lock on the trigger.
Precisely. Under this civil RICO statute, it's not enough to just be hurt by a racketeering enterprise.
Okay.
The statute explicitly says you must be injured, quote, by reason of the violation. And the courts have interpreted that tiny phrase to mandate a concept called proximate cause.
Proximate cause, meaning the harm has to be incredibly direct.
Exactly.
It's like setting up a complex domino chain. The fraudsters knock over the first domino, which is the construction companies who get hit with the fake lawsuits.
Right, step 1.
And that knocks over the second domino, the primary insurance companies who sold the liability policies to the construction sites.
Step 2.
Which then knocks over the third domino, Ionian Re, the reinsurer, who ultimately reimburses the primary insurers.
That is exactly how the court views the chain of causation in those 3 distinct steps. And the Supreme Court established the strict proximate cause rule because calculating ripple effect damages is just a mathematical nightmare for a judge and jury.
Oh yeah, if you think about it, if the primary insurer sues the fraudsters for the stolen money, and the reinsurer also sues the fraudsters for reimbursing that exact same stolen money.
Who gets what?
Exactly. Who gets what?
That is the exact problem the courts want to avoid. It's called double recovery.
Okay.
If you let every single domino in the chain sue the person who flipped the first domino, the court would have to perform this impossible judicial algebra to figure out exactly how much of the reinsurer's loss was passed on, how much the primary insurer absorbed, and how to apportion those treble damages without punishing the defendant twice for the exact same dollar.
That sounds like a mess.
It would be. So the Supreme Court drew a hard line. Only the first guy in line gets to sue.
But wait, doesn't the law care that the fraudsters knew the reinsurers would ultimately foot the bill? I mean, these are sophisticated lawyers we're talking.
They absolutely knew.
So foreseeability has to count for something. They knew exactly who was writing the ultimate check at the end of the day.
You would think so, right? But the Supreme Court has definitively said no. Foreseeability simply does not cut it in an RICO case.
Really?
Yeah. Judge Kuntz actually cited a trio of Supreme Court precedents that perfectly illustrate why Ionian was thrown out, and they show just how ruthless this tunnel vision can be.
Let's walk through these, because to a layperson, they seem to just fly in the face of common sense.
They do. So the first is a case called Holmes. In Holmes, there was this massive stock manipulation scheme.
Okay.
The fraud directly hurt the broker-dealers who were trading the stock, but there was a corporation whose sole job was to insure those broker-dealers.
That's familiar.
Right. When the market crashed because of the fraud, the insuring corporation had to pay out millions, so they sued under RICO. The Supreme Court said no. The harm to the insurer was purely contingent on the harm to the broker-dealers. They were step 2. Case dismissed.
Wow. Okay, so if the Supreme Court blocked an insurer in Holmes, I'm guessing they applied that same strict standard to other secondary victims? Did anyone else try to bypass this?
Oh, they definitely tried in a case called Onza. This was a dispute between 2 steel companies.
Okay.
One company committed tax fraud, didn't charge sales tax, and used those illegal savings to drastically undercut their competitors' prices.
Sneaky.
Very. The competitor lost a ton of business and sued under IHO. The Supreme Court said no again.
Wait, I have to push back on that. The entire purpose of the tax fraud in Onza was to drive the competitor out of business.
That was the goal, yes.
It wasn't an accidental ripple effect. It was the weapon itself. Why doesn't the competitor have a right to sue?
Because the court doesn't care about the ultimate intent. It cares about the actual physics of the crime. Right. The direct mechanism of the fraud was unpaid taxes. Therefore, the state was the direct victim of the mechanism. The competitor losing business, even if it was the fraudster's main goal, was a secondary ripple effect. Case dismissed.
So the law is essentially saying, we don't care why you pulled the trigger, we only care who the bullet hit first.
That's a brutal way to put it, but it's completely accurate.
That is incredibly strict.
And the final nail in the coffin for Arian is a case called Hemi.
What happened there?
In Hemi, an online cigarette merchant didn't file required customer information with the state. New York City sued under RICO, saying they lost tens of millions in tax revenue because without that info, they couldn't track down the customers who owed taxes.
Then let me guess.
The Supreme Court explicitly ruled that foreseeability is entirely insufficient. The conduct directly responsible for the city's harm was the customers failing to pay their taxes, not the merchant failing to file the paperwork.
So in RICO, the law literally has absolute tunnel vision.
Absolute tunnel vision.
It refuses to look past the very first domino. If you are the second or third domino, you have no standing. You just cannot sue the person who started the chain reaction.
Exactly.
And because Ionian is a reinsurer, reimbursing a primary insurer, reimbursing a construction company, they are 3 steps removed.
Right. As the Supreme Court put it, the general tendency of the law is not to go beyond the first step.
But, and this is a huge but, there is a massive secret hiding in plain sight regarding how Ionian Re actually operates.
Yes, there is.
And it's a detail that Ionian desperately tried to use to save their entire case at the 11th hour.
This is where the difference between a company's name and its actual mechanical function becomes basically everything.
Here's where it gets really interesting. When you hear the name Ionian Re LLC, you immediately think it's a traditional reinsurance giant.
Right, like Munich Re or Swiss Re.
Exactly. A massive open market company that just sells insurance to other insurance companies. But the industry intelligence reports sitting right here on our desk paint a completely different picture.
A very different picture.
Despite having Re in their name, multiple reports explicitly describe Ionian as a captives insurer, specifically a Vermont-domiciled captive for a parent company called Andromeda and its affiliates, serving New York's construction industry, like Skyline Restoration, Inc.
We really need to clarify what a captive insurer actually is, because it completely changes the financial reality of this whole case.
Go for it.
A captive insurer is essentially an insurance company that is wholly owned and controlled by its insureds. Its primary purpose is to insure the risks of its owners.
So it's essentially corporate self-insurance.
Exactly.
It's like a big construction company deciding, hey, instead of paying massive premiums to a giant outside insurance corporation, we're just going to put our emergency savings into our left pocket instead of our right pocket, and we'll give our left pocket a fancy corporate name like Ionian Re.
That is the perfect way to look at it. It is a specialized risk financing vehicle. Now, the way this often works mechanically and why the word re causes so much legal confusion is through a fronting arrangement.
A fronting arrangement.
Right. New York law requires construction sites to have official licensed insurance. So a traditional fronting carrier issues the actual policy to the construction company just to satisfy the state.
Okay, that makes sense.
But then that fronting carrier immediately cedes, or passes, that retained risk right back to the captive insurer, in this case, Ionian.
Oh, so the captive is acting like a reinsurer,
Yeah.
accepting the risk from the fronting carrier. But in reality, the money never left the family.
Not at all.
Ionian Re is essentially the financial alter ego of the construction companies themselves.
Exactly. And you can imagine the sheer panic when Ionian's legal team realized their mistake.
Oh, man.
In their legal briefings opposing the motion to dismiss, they suddenly realized that calling themselves a reinsurer was leading them straight into the buzzsaw of those Supreme Court precedents we just talked about.
Right, because if they are a reinsurer, they are domino number 3, and they lose.
Automatically. So they frantically tried to change their story. They execute this massive about-face and argue to the judge that they aren't a traditional reinsurer at all. They claim they have a first dollar pay obligation.
Meaning they actually pay the claim expenses before the primary insurer's obligations are triggered.
Right.
Because they are the captive, they just pay the deductible right out of the gate.
They are basically arguing, hey, we aren't reimbursing anyone. We are writing the very first check.
Okay, so if Ionian actually pays the first dollar because of their captive structure, doesn't that instantly make them the direct victim?
You would think.
If they write the first check, they're step 1, not step 3. The whole dominoes metaphor completely collapses. Why didn't Judge Kuntz just accept that and let the case proceed to trial?
If we connect this to the bigger picture of civil procedure, this is where the harsh reality of the rules of the court comes down like a hammer. A judge is evaluating a motion to dismiss, right? A motion to dismiss basically means the defendant is saying, even if everything you say in your lawsuit is 100% true, the law still says you lose.
Right.
And the key rule here is that a plaintiff cannot amend their complaint through their briefing.
Wait, meaning you can't just change your foundational story in the arguments you submit to the judge after you've filed your official lawsuit.
Exactly. Your complaint is the anchor of your entire case. It establishes the universe of facts the judge is allowed to consider. And in Ionian's actual official amended complaint, they repeatedly referred to themselves as a reinsurance company.
Oh, no.
They repeatedly stated their injury came from reimbursements they made to primary insurers. They literally defined themselves as step 3 in the chain in their own paperwork.
So they wrote their own death warrant in the complaint.
They really did.
I guess if we let people change their story mid-argument, just because they realize they're losing, lawsuits would be absolute chaos.
Completely unmanageable. So the judge looked at their new argument about being a first dollar payer, looked back at the complaint and said, I can't find this anywhere in your official allegations. In fact, your complaint says the exact opposite.
Wow.
Because they pleaded themselves as a reinsurer, the judge applied the law for reinsurers, and that law demands dismissal.
So what does this all mean for you? It means that in the eyes of the law, the precision of your words matters just as much, if not more, than the millions of dollars you lost.
Absolutely.
You can be the victim of a massive coordinated fraud involving fake surgeries and corrupt lawyers. But if you mislabel your own corporate function in your legal complaint, the court will just shut the door in your face.
It is a brutal, brutal lesson in the mechanics of litigation. But there is a crucial caveat here that leaves a very specific door open for the future.
Right. This isn't necessarily the end of the raid. So what happens now?
Well, Judge Kuntz dismissed all of Ionian's federal claims, the substantive RICO claim and the RICO conspiracy claim. He also declined to exercise supplemental jurisdiction over their state law fraud claims, which is standard practice when all the federal claims are gone. But he dismissed the complaint without prejudice.
Which is legal speak for, you survived on a technicality, you can try again.
Exactly. He gave Ionian exactly 30 days from the date of the decision to file a new amended complaint.
Okay.
And he was very specific. They must include a redlined version showing exactly what they changed, and they must cure the specific deficiencies identified in his opinion.
In other words, they have 30 days to legally prove they are actually domino number 1.
Right.
They have to formally plead the reality of their captive structure and show that they paid the first dollar directly because of the fraud, without contradicting their earlier filings to the point of absurdity.
It will be an incredibly delicate balancing act for their legal team. I mean, they have to completely redefine their corporate identity to the court without looking like they're just making it up to survive the motion.
It's going to be a very tense 30 days for those lawyers.
Oh, without a doubt.
Which leaves us with a final lingering thought to ponder as we wrap up this deep dive. Think about the last time you bought insurance or looked at the complex corporate structure of a major company. If a captive insurer, like Ionian Re appears to be, is essentially an in-house financial vehicle created by the construction companies themselves, they are, in a practical dollars and cents way, the exact same entity as the direct victim.
Right. The money all comes from the same ultimate pot.
Exactly. Yet the strict legal veil of calling themselves a reinsurer, a layer of corporate separation they created for their own tax and liability benefit, almost cost them their day in court entirely. This raises an important question. As modern corporations create increasingly complex, multi-layered financial structures, captives, subsidiaries, holding companies, to protect their assets and manage risk, are they inadvertently building rigid legal shields that actually protect the fraudsters who steal from them?
That's a great point.
If the law refuses to look past the first domino, does building a longer chain of dominoes just make it easier for the people knocking them down to get away with the money? Thank you for joining us on this deep dive. Keep questioning the structures you see and keep exploring the hidden layers of the systems around you.